Court of Appeal in and for the 5th District of the State of Florida is now in session. Your Honorable John M. Harris, Judge, presiding. All persons having business before the court will draw near, give attention, and you will be heard. May God save the United States of America and the state of Florida and this honorable court. Please be seated.
Good morning. Welcome to the oral argument session here at the 5th District Court of Appeal. Let me introduce the judges on the panel. As Marshall said, I'm Judge Harris, joined this morning by Judges Cohen and Judge Wozniak. If you have any electronic devices, please go ahead and either turn those off or silence them at this time so the arguments are not interrupted today. And this is just to remind you the argument today is being recorded and live streamed on YouTube. Each side has 20 minutes for the argument. Appellant can reserve as much of that time as you would like for rebuttal. The default will be 5 minutes. If you want anything other than that, please let me know. First case on the docket today is case number 21-1087, Robert Dumagin v. Holmes Regional. Appellant, if you are ready, you may proceed.
Good morning, Your Honors. I'd like to request 5 minutes for rebuttal.
You got it.
My name is Stephen Biggie. I am the attorney for the appellants Robert Dumagin and the estate of Edith Dumagin from the law firm of Arcadia, Biggie & Wood in Melbourne, Florida. We're asking today for this court to overturn the directed verdict entered in favor of the defendants and to remand the case back to the circuit court for trial for the following 3 reasons. The first reason is there's substantial competent evidence to support a verdict for the plaintiff. Therefore, the ultimate outcome of the trial should be decided by a jury. The second reason is that the trial court committed a reversible error when it disregarded the plaintiff's circumstantial evidence and categorized it as an impermissible stacking of inferences. And the third reason is that the defendant's directed verdict relies on spoliation of evidence and argues facts and demands inferences in its motion in a light most favorable to the defendant, which is impermissible.
Well, you think the spoliation is your strongest argument?
No, I do not, Judge.
Because it strikes me that here it wasn't that anything was destroyed. It's just that the hospital didn't keep records of certain events, the tracking of the vials, that type of thing, and is that spoliation?
Yes, Your Honor. Our strongest argument is
No, you set forth. I'm going to take spoliation, then we'll go from there.
I understand, Your Honor. The spoliation issue is that medical providers, particular hospitals, when they're providing surgeries or performing surgeries, have a duty to record and maintain.
This wasn't a surgery. This was a recall of heparin, of allegedly tainted heparin. Did they have what duty? Did they have a legal obligation to record those? Now, I'm not saying that you can't use their failure to have tracked it and recorded it, as part of your proof, but you understand that if that instruction is given and it's given erroneously, that you're going to be right back here.
I understand, Your Honor. I don't believe the instruction would be erroneous.
The question is there a difference between what legal duty did they have to record those lot numbers when they were gathering up the tainted heparin?
It was the recall standards promulgated by the federal government because they opted into, when you accept Medicare, you have to opt into certain regulations, and one of those regulations regarding recalls is when you perform a recall, you have one of 2 options. You have an option of recording all the lot numbers, what comes in, what comes out. Therefore, when you conduct the recall, you can cross-reference, check, and make sure you got everything. The other...
So what is there a specific code that requires that, and if so, what is it?
There is a specific code. I do not recall the code at this
Did you
time.
include that in your brief? I don't recall right offhand.
I don't remember specifically, Your Honor. It would be.
Well, when you're on rebuttal, why don't you look and see whether, you did that? So let's move on then to.
Yes, Your Honor.
Your arguments. The inference, stacking of inferences, was that not addressed at summary judgment?
It was addressed at summary judgment. It was addressed in our favor. Well, let me take a step back, Your Honor. The case at summary judgment was initially entered against us in favor of the defendant with the stacking of inferences ruling. And then we came to the Fifth, and the Fifth looked over the case and said it's based on Dr. Levin's opinion.
And the opinion didn't specifically utilize the phrase stacking of inferences, correct?
No,
I'm going to call this, Dumagin 2.
Okay.
First we've got the medical malpractice issue, and I was on that panel. Then we've got a second appeal from the granting of summary judgment. Let's, for sake of discussion, call that Dumagin 2. The stacking of inference was briefed and argued in that case, was it not?
It was.
Okay. And so, but the opinion didn't specifically address, or at least explicitly address that issue, but more implicitly addressed it. Is that correct? That's your argument?
It did not expressly address it, but the opinion said based on Dr. Levin's opinion and the loss of the lot number, there's a disputed issue of material fact has to be decided by a jury, Your Honor.
Okay. All right, and then your argument as to why this isn't stacking of inferences, what?
Your Honor, it's not a stacking of inferences because we go back to the same issue that was argued in Dumagin 2. An expert opinion is not an impermissible stacking of inferences. And the expert opinion of Dr. Levin was that after...
And can it ever be?
I've seen cases where it says if an expert assumes facts not contained in the record, it would be. But that was not the case in Dumagin 2, and that's not the case here in Dumagin 3. Our expert based his opinion on the medical records of Mr. Dumagin, which is direct evidence. So the opinion itself is direct evidence, which is not an impermissible stacking of inferences. The medical records themselves are direct evidence, so that's not an impermissible stacking of inferences. So, from Dumagin 2 and Dumagin 3, it's the same issue where, our doctor, our hematologist reviewed medical records and said, well, based on the way his body reacted, based on test results, based on...
And is this court's review of a directed verdict any different than review of summary judgment? It
is slightly different, Your Honor. The standards for summary judgment and directed verdict are a little bit different. But I think in the context of this case, it's, we're really dealing with the same thing. And the issue is there enough evidence for a jury to take this case and render a verdict in favor of the plaintiff? And this court previously said in Dumagin 2, yes, there's enough evidence based on Dr. Levin's opinion to take this case, review it, and enter a verdict for the plaintiff. And I think that holding, should have been considered by the circuit court in denying the motion for directed verdict. That was argued at trial, that it's basically the same issue. Is there enough evidence for a jury to render a verdict in favor of the plaintiff? This court previously said yes in Dumagin 2, so the answer should be the same. It should have been the same from the circuit court, and we're asking that same methodology and holding be applied to Dumagin 3 as well, Your Honor. Essentially, the opinion of Dr. Levin is that there's differences between, and we'll talk about heparin-induced thrombocytopenia, how it appears normally and how it appears with OSCS contamination or oversulfated chondroitin sulfate contamination. And some of the issues that differentiate is when our client was given the heparin from Dr. Abad, he experienced hypotension, which continued even after he was off of bypass. It was the speed at which his platelets were dropping was unusual compared to a normal case of heparin-induced thrombocytopenia. There was also an issue that Mr. Dumagin had a subsequent exposure to heparin in 2010 without a reaction, and if he had had a reaction to heparin, uncontaminated heparin in 2008, he would have had a similar reaction in 2010, which did not occur. There was also the positive HIT test and the edema as well, which is swelling. The medical records indicated that there was swelling in Mr. Dumagin's body. Mr. Dumagin's son testified that when he traveled from New York to Florida to visit his father after his father was in a coma, his entire body was swollen up, which was also one of the factors that appear when you're have this hit related to oversulfated chondroitin sulfate contamination. And he said based on, within a reasonable degree of medical certainty, more likely than not, he was given contaminated heparin.
All right. Now I'm going to address just another issue very briefly, which is you had a doctor that was going to come in, I believe it was a heart surgeon, who was going to testify that he stopped doing surgeries because of what could potentially be heparin contaminated issues, correct?
He specifically said, I am suspending my surgeries because of an outbreak of heparin-induced thrombocytopenia. He did not specifically say it was related to OSCS. I don't think they really knew enough about OSCS at the time to link the two together. But what that particular...
But didn't he also say that it could have been a malfunction of a machine?
He could have. It was... It's circumstantial evidence, Your Honor, and basically what it points to and what we're saying that it infers is that they did not remove all of the contaminated heparin because they were still having a statistically significant
So it's a
increase.
relevancy issue.
Correct.
The question is, does it tend to prove an issue in dispute?
Correct. Whether or not contaminated heparin was still on the facility. So if these issues were occurring in June and July of 2008, then there's still contaminated heparin in the hospital dating back to when they purchased it, because they purchased the contaminated heparin at the end of 2007, beginning of 2008. Recall started in, I believe, mid-January, February, and March. And, Mr. Dumagin had a surgery in May, and they're still having this statistically significant increase in HIT positive patients in July. So how it pieces it together is that it's circumstantial and infers that yes, they still have contaminated heparin even in July of 2008. So that would be a relevancy issue. The stacking of inferences ruling that went against us, we don't believe the circumstantial evidence is impermissibly stacked in this case. They talk about the cases that were cited in my brief about parallel inferences, where parallel inferences are a group of independently verifiable facts that point to the same inference or inferences. And I think that's where the error occurred, is that there's a lot of circumstantial evidence and there's direct evidence in this case. They all point to very similar inferences. One, that there was contaminated heparin in the hospital. Two, that contaminated heparin was administered to Mr. Dumagin. And I think the trial court just made an error when it said that we had to, that it was impermissibly, or it was impossible for us to show that based on our circumstantial evidence that Mr. Dumagin had received contaminated heparin.
Let me talk to you about something that's a little troubling to me, which is the case never got to a jury. This case has been going on for over a decade now.
That's correct.
It's time that this case gets resolved one way or the other. But how do we get to the issue of the jury instruction and, for instance, the evidentiary, the evidentiary issue about the heart doctor, perhaps, perhaps that's something that we can reach. But can we get to the issue of the jury instructions when it never got that far?
I'm not sure. I think my bigger concern with the spoliation issue is the fact that we were kicked out of court on a directed verdict based on their defense that they didn't record the number, that they destroyed it, and that their entire defense is based on that fact.
I don't know that their entire defense is based on that fact. We never have seen their case yet.
I'm sorry. Correct. But let me rephrase that. The directed verdict was really based around that particular argument that we couldn't prove, the jury couldn't reach a decision in favor of the plaintiff without actually having the lot number of the bottles that Dr. Abad had administered, because our entire case was, as they argued, impermissible stacking of inferences. So it was central to that particular argument. So that's why I believe it needs to be.
I'm struggling with it because I don't want to see you all back here a fourth time.
I understand. As far as the jury instruction.
Don't take that personally.
No. I'm fine with that, Your Honor. As far as the jury instruction issue is concerned, it'll go if we go back to the trial court. We're expecting the evidence to be the same, or it may be a little bit different, and maybe the instruction will be more appropriate or less appropriate depending on what happens at the second attempt to try the case, Your Honor. But we don't have to have that result in our favor in order to have the case remanded. I think that.
I understand that.
Yeah.
I'm just trying to avoid the fourth appeal.
I would love to do that as well, Your Honor. I understand. I see that I'm out of time. I'll reserve the rest for rebuttal.
Okay, thank you.
Please, court.
Good morning. I'm Andy Bolin. I represent Holmes Regional Medical Center in this matter. I was trial counsel as well.
Let's start with the exclusion of the testimony from the heart doctor as to stopping of surgeries.
Sure.
The Holmes Regional has taken the position that all of the tainted heparin had been removed. I'm not sure how you get there when you didn't make any effort to record vials and track the vials from what went in and what went out. But why doesn't the fact that this doctor stopped performing surgeries because of continued heparin or arguably what could have been contaminated heparin results, why wouldn't that tend to prove that the hospital had not successfully removed all of the tainted heparin?
For a couple of reasons, Your Honor. I think the first and most important is that in Dr. McKinney's testimony, nowhere did he suggest that he suspected that his patient's complication rates were caused by oversulfated chondroitin sulfate or contaminated heparin. What he said was that in that time period, he began to see what he believed to be a statistical anomaly in terms of the number of complications his patients were suffering from.
That were consistent with contaminated heparin.
It could be, Your Honor.
Well, okay.
But
this is a relevancy issue. The question, and the jury could, you could say, well, it could have been caused by some other event. The machine, I think, was what his testimony was. But doesn't that tend to prove the existence of contaminated heparin still at the hospital?
It does not, Judge, and here's why, is because these are complications or incidents that occurred in other patients. And so just like when we have incidents where there is other alleged malpractice that occurs in a medical malpractice case, we don't allow someone to come in and talk about all of those other incidents. It would require us to...
That's a medical malpractice issue. This is more of a, this is a negligence issue in terms of how the hospital handled the recall of tainted heparin.
I would submit that the analysis is the same for the same reasons, because what Dr. McKinney says is that he had a higher rate of complications. Now, interestingly, the complications that he saw in his patients were not the complication that Mr. Dumagin actually suffered from.
But the issue goes to whether the tainted heparin remained at Holmes Regional.
Correct, but nothing within Dr. McKinney's testimony and his patients ever suggested that it was caused by contaminated heparin. In fact, the hospital did an investigation, which Dr. McKinney testified to, and they found, number one, no statistical anomaly in terms of the number of patients that he perceived.
That's what you get to present as part of your case, or on cross-examination of McKinney.
And I believe Dr. McKinney himself, at the end of his testimony when I was cross-examining him during his deposition, I asked him specifically, are you suggesting that you either believe or that you are attributing any of these to potentially contaminated heparin? And he stated unequivocally that he was not. So what we would be doing is taking a heart surgeon who had complications, who he himself is not suggesting was caused by oversulfated chondroitin sulfate, and allowing the plaintiff to come in and use those complications and say, despite what the heart surgeon himself says, despite what the hospital says, we believe it could have been caused by that, even though they are entirely different complications that actually occurred.
Well, let me switch gears on you then. I've been involved in this case previously, and so, but I wasn't involved in Dumagin 2, but of course, I'm sure we all, as part of our preparation for this case, took a look at that opinion and looked at the briefs and listened to the oral argument in the case. It seems that this issue was briefed and argued in Dumagin 2. Was it not?
So the issue in Dumagin 2...
That's a yes or no. Was this issue briefed and argued in Dumagin 2?
I did brief that, and I raised that as an issue in Dumagin 2, correct.
And, and that opinion, while not specifically addressing the stacking of inferences, reversed the fact that you had gotten a trial judge to award summary judgment. Correct?
Correct. The summary judgment was reversed.
So what are we doing here?
Well, number one, I think that the issue that was the subject of the opinion of this court was the fact that there was an expert who said that he believed more likely than not that the patient received.
But your argument in that appeal was this expert's testimony is not credible and admissible because there was a stacking of inferences.
Correct.
And the court there said, no, this expert's testimony is sufficient to defeat summary judgment. It's the same issue you're raising here.
The directed verdict, however, Your Honor, was actually awarded on previous stacking before you ever get to the expert's opinion. So in other words,
No, that's, it all goes to Levin's testimony. This is all about Levin's testimony. It's not about any other evidence, in this case. It's about whether Levin's expert testimony stacked inferences.
right.
And that hasn't changed since Dumagin 2. It's not like this was a case where certain evidence was presented at summary judgment and then at trial, that evidence didn't pan out. The evidence that was presented as part of the summary judgment is the same evidence that came out and is presented as part of the directed verdict.
So what we said at summary judgment phase was that Dr. Levin's testimony did in fact stack inferences and that his testimony was not sufficient to overcome a summary judgment. The trial court in this case, when she granted directed verdict, looked at the initial inference, which is, was there contaminated heparin in the hospital to begin with? And there is no direct evidence that there was contaminated hospital in the hospital.
Because, as Judge Wallace pointed out at oral argument in Dumagin 2, you all didn't track it.
Correct, Your Honor, but as...
And if the evidence that you're relying upon for that proposition is, well, oh, we did it fine, and there was no tainted heparin left, why would they have then been continuing to look for tainted heparin both at the day of the surgery and subsequent to the day of the surgery, where they were continuing to look for tainted heparin? If they knew that all the heparin had been removed because they had properly tracked it and and compared lot numbers, there would have been no need to have continued to search, would there have been?
So, Judge, I don't believe there was any evidence that they were looking for tainted heparin either on the day of the surgery or subsequent to the surgery. The testimony was that there were...
You don't think that, you don't know there was testimony that said they were continuing to search for tainted heparin?
So there was testimony, Your Honor, that there were two phases of the recall. The first recall was that Baxter Pharmaceuticals had asked for certain lot numbers to be pulled from the shelves, which is what the first phase was.
And you all didn't track the lot numbers.
We did not, Judge, and there is no, as you pointed out, I believe, during appellant's argument, there is no statutory obligation or legal obligation.
No, but you're making a claim that there was no tainted heparin, and had you done that, had you tracked those lot numbers, we would know that, wouldn't we?
I suppose so. However, what I would point to is the plaintiff's own pharmacy expert, in this case, Mr. Hawkins, says that although that is an option, although an option would be to track lot numbers, he knows of absolutely no pharmacy that has ever done that. And that's the plaintiff's own expert. It is a onerous and burdensome process that no pharmacy does. What Mr. Hawkins said is, if the hospital were to do what Holmes Regional did, which is to go out the second time after the recall was expanded and pull all Baxter Pharmaceutical from the shelves, which is what Jill Walling, the pharmacy manager, said occurred, then they would have met the standard of care as it relates to the recall. The problem with this case, and from that respect, is that Mr. Hawkins was never provided with the testimony that Jill Walling did the second half of the recall. And that was within the cross-examination at trial, is that...
Suggesting that it's not a tough case for the plaintiff, but the issue here is whether these are issues for a jury to determine.
Well, I think, Judge, that...
And that goes right back to the stacking of inferences that was addressed in Dumagin 2.
I disagree that it was the same issue addressed in Dumagin 2, because as the Volcker case says, you have to be able to prove the first inference, the first piece of circumstantial evidence, beyond and to the exclusion of any other reasonable inference that can be drawn from it. And that's what the trial court looked at. The trial court looked at the first inference, which was, is there circumstantial evidence, or at least an argument that the jury could receive, that suggests that there was contaminated heparin within the hospital?
Let me ask this. Let's assume that there had been no recall, and that you had a doctor that was going to come in and was going to testify that based upon these events that occurred during the course of the surgery and this reaction by a patient, that this patient was given contaminated heparin, that's what would cause these specific events that occurred during the course of the surgery and following the surgery. Why would that not be sufficient in and of itself, regardless of the recall issue?
Because there would be absolutely no basis for the expert to make that determination. So that would be...
He's going to testify in his expert opinion that, the drop in the blood pressure, well, the drop in the blood pressure was explained somewhat, but the drop in the blood pressure, the swelling, the other, the other factors that occurred to this patient, that he's going to testify in his opinion, within a reasonable degree of medical certainty, that this is caused by contaminated heparin. I mean, doesn't that occur every day in medical malpractice suits throughout the state and throughout the country?
Judge, I don't know that it does, because you would still have to be able to prove that there was in fact contaminated heparin somewhere that could have reached the patient and been administered.
Why? I mean,
because
he's going to testify that that's what had to occur in this case. That's within a reasonable degree of medical certainty. He's going to testify that's what caused these problems. Don't doctors, and don't experts testify to that in malpractice case after malpractice case?
Certainly experts testify as to their opinion as to two sets of competing facts. But there has to have, the expert's opinion has to be underpinned by actual evidence. And in fact, it's cited in...
Can't the actual evidence be what occurred to the patient? Isn't that actual evidence?
Well, certainly the outcome or the existence of a complication cannot be used to prove malpractice. That's stated in Florida law. So we can't necessarily say because there's a complication we can infer there was malpractice. That certainly can't happen. Now, what happened in this case is that Dr. Levin, and he admits this in his cross-examination at trial, is that his opinions are that the damages were caused by contaminated heparin based upon the assumption that the patient did in fact receive contaminated heparin. So Dr. Levin didn't say, I know, or based on the facts, I think contaminated heparin entered the room. He based it on the assumption that contaminated heparin entered the room, and that's...
So as long as they can't produce a witness who's going to come in and say, well, we were there and he got contaminated heparin, he's out of court. Is that your position?
Without direct evidence that contaminated heparin made it into the operative suite, correct. He cannot prevail.
Where would you get that direct evidence from?
Well, there would have to be some evidence that the heparin that was in the hospital that day that made it to the operative suite was in fact from the batch of contaminated heparin.
Where would you ever get that evidence from?
I don't know, Judge. It's not present in this case, and that's the problem.
I'm asking you, in any case, where would you get that from?
Well, for example, there are lot numbers recorded on the operative notes from the...
Not the heparin that the anesthesiologist gave.
Correct, but the anesthesiologist says that he obtained his heparin from the pharmacy itself. The pharmacists confirmed that the heparin had been recalled and was no longer present in the pharmacy. And the plaintiff's theory, remember, was not that it came from the pharmacy. The plaintiff's theory was that Dr. Abad somehow brought it into the hospital or introduced it into the operative suite. So even the plaintiff himself, and I suspect it's because of the testimony of the appellate's expert who said that the standard that was used by Holmes Regional would have been reasonable, but even they don't suggest that it came from the pharmacy. Their theory was that it came somehow through Dr. Abad, because we know that the only heparin that wasn't accounted for by lot number on the date of the surgery was Dr. Abad, the anesthesiologist's drugs. And so that's why the court then looked at the issue of, can you jump from the circumstantial evidence or the inference that there may have been heparin somewhere in the hospital to the inference that Dr. Abad introduced it into the operative suite. And that second inference, which was stacked upon the first circumstantial evidence, is what the trial court found fatal to the ultimate case, because of the way that the evidence was presented by the appellate, saying specifically that it must have been Dr. Abad who introduced it, because the perfusionist who wrote down his lot numbers on the operative form, it was concluded that those lot numbers were not part of the contaminated recall. So it really focused on Dr. Abad, and that's why there's a difference between the motion for summary judgment argument and...
testified that he got the heparin from what he describes as similar to a Craftsman toolbox. That's what his testimony was as to where the heparin was retrieved from, and my recollection is that that wasn't one of the places that was searched when they were looking for tainted heparin.
So there was evidence that those they're called heart boxes, those were
green boxes, I think.
Correct. Those were searched for contaminated heparin during both the first and second phase of the recall, and that was testified to by Joe Walling. But nevertheless, the heart box that was used by Dr. Abad on the date of the surgery came from the pharmacy. Dr. Abad testified to that. And Joe Walling, who's the pharmacy manager, also testified as to how those heart boxes are put together. And those heart boxes are put together on the date of the surgery from the pharmacy based on the preferences of the physicians who will be involved in the procedure itself. And so that's why when the trial court looked at it, they said, okay, the first inference that's drawn that says somehow Holmes Regional didn't do their job and tainted heparin still exists in the hospital, that's circumstantial, but you can get past that. But the problem is getting it.
This sounds exactly like what you argued in your brief in Dumagin too. This is exactly what you argued.
I did, and candidly, I believe that the Dr. Levin's testimony suffered from that fatal flaw then too, because it was based upon an assumption that there was contaminated heparin in the room. But we had not yet had that presentation of evidence, and that was under the old summary judgment standard. So I think that the old summary judgment standard was an easier bar for a plaintiff or appellant to hurdle than perhaps now when the summary judgment standard and directed verdict standards are more aligned. But nevertheless,
Well, I like that. You're arguing that you would have won the last appeal under the new summary judgment standard? Is that what you're arguing here?
I think that I think that the result may have still been the same because we were focused on Levin's testimony only, not on the stacking of inferences that gets us to the fact that Dr. Levin.
You talked about it in terms of circumstantial evidence, but it absolutely was a stacking of inference argument that you briefed and argued in that appeal. It absolutely was the same.
And so, as I said, I think the trial court's determination wasn't based on Dr. Levin's testimony in this case. It was based on whether or not there could have been tainted heparin in the room and how Dr. Abad would have introduced it. I'd submit that the trial court's determination that directed verdict was proper should be upheld. That the Volcker case stands for the proposition that if you are going to stack circumstantial evidence on circumstantial evidence, as the plaintiff did in this case, that the initial inference has to be proven to the exclusion of any other reasonable inference in the case. And in this case, the appellant was unable to do that, and therefore, under Florida law, the directed verdict should be upheld. Thank you.
Thank you.
May I proceed?
You may. You've got 4.5 minutes.
Thank you.
Is it your theory that Abad, do you agree with Eppley's statement that Abad brought this heparin in some outside fashion other than retrieving it from the heart box?
No, Your Honor. The issue with Dr.
That was simply a speculation that was raised in part of one witness's testimony, correct?
Correct. The issue with these disputed facts, Your Honor, I believe, their pharmacy expert testified as to the procedure of how heparin is delivered from the pharmacy to the surgical suite, but Dr. Abad's testimony was he didn't recall anything that happened that day other than what was in his surgery notes, which didn't state where the heparin came from, who delivered it.
Okay, but there was testimony that the heparin would be retrieved from the pharmacy either the day of or the day before the surgery, is my recollection of it, correct?
That is their operating procedure, but there's no testimony that that is what actually occurred on the day of the surgery, Your Honor. I think there's a difference between the two. So this is what we normally do. Normally, this is the hospital procedure, but there's no one that testified.
Well, doesn't heparin break down fairly quickly if it isn't kept in a refrigerated state?
No, it could last for months. When the testimony came from Jill Walling, when we asked her, when on the stand, you're returning this heparin in February and March, when was it originally purchased? And it was originally purchased in November. So that heparin that they were sending back in February had been there for 4 months. Is
heparin refrigerated within the pharmacy or not?
I don't know. I don't know whether or not it's refrigerated. I know once you use it, then it only has a shelf life of 24 to 48 hours. When you don't use it, it could be on a shelf for months. It could last for months.
All right. Did you have an opportunity to look up the issue that we had discussed earlier?
Yes, Your Honor. I didn't cite it directly in my brief. I believe I cited to the testimony that references it, but I didn't cite directly to it in the brief itself. So it should be in the appendix, Your Honor. I just wanted to address some factual disputes from a defendant's argument. It was raised that Dr. Levin was asked if he had to make assumptions to reach his opinion, and opposing counsel represented that he answered yes. That's not correct. He was asked during cross if he had to make assumptions to reach his opinion, and he said no. His testimony to answer that question from opposing counsel was no. He didn't have to make any assumptions. Regarding direct evidence of whether there was contaminated heparin on the property, the return records say, you know, returned July 2008 for some of the heparin that was returned. And I know there was some disputed facts over whether that was when it was credited or when it was actually returned. Again, disputed fact. And it says right on the record, return. It doesn't say credited, paid, money received, anything like that. It just says returned, or return on July 2008. And I believe it was Brooks Lyles testified that heparin was kept in the heart box, the blue box, and the anesthesia cart. And what Ms. Walling had testified to, she didn't know that heparin was stored in anesthesia carts. An anesthesia cart is what an anesthesiologist uses during surgery. So she didn't know heparin was stored there.
And so is the inference drawn that they weren't, since she didn't know that they weren't searched?
Correct.
Is there any evidence to the contrary as to that issue?
Her testimony was that she sent people out to everywhere their heparin was stored. And, you know, can you be more specific? She said, you know, pharmacy and Pyxis machines. She never said anesthesia. She sent anyone to anesthesia carts. And when she was asked, is it stored in anesthesia carts? She said, I don't think so. I don't know. That was her testimony. And Mr. Lyles, who is actually a perfusionist in the surgery suite, said, yes, it is stored in anesthesia carts and blue boxes. And
Is there evidence that heparin could remain in an anesthesia cart for an extended period of time? Or was the testimony that the anesthesia carts were stocked the day before or the day of the surgery?
There was no testimony one way or the other, specifically what happened the day of Mr. Dumagin's surgery, but there was testimony regarding their procedure.
Right. And was the procedure to stock those carts the day before or the day of the surgery?
The way they stock those carts, Your Honor, is it's kind of like a grocery store, where it's like, okay, I have 3 bottles of heparin, so I put it, and I usually carry 8, so I put it in order for 5. So there will be some rollover on it, but that's generally how it works. It's like a restocking. It's not a total, they don't toss out unused medication. It'll stay there until they use it. So if it's a stocking situation and you leave it there, you know, it's not, and it doesn't get used, it'll stay there. So if he hadn't used it or it hadn't been pulled, then it would stay there.
Was there evidence as to how long typically they would go through the heparin in one of those carts?
There was no evidence presented one way or the other.
All right, thank you, counsel, for your arguments. That concludes our first case for the morning.
All right.